Okay, thank you, Brittany. As Brittany stated, my name is Michael Follins. I'm a managing partner here at Tully Rinckey. I'm joined by my colleague, Nora Ezzat Cozzillio, an associate here at Tully Rinckey. We both work in our Federal Labor and Employment Practice Group, and we defend the rights of federal employees and work on federal employment issues across the federal government. We're here today to talk about one of the most recent presidential mandates, which is the return to in-person work order. We're here to discuss that order and the OPM guidance that's been issued in relation to that. We'll also be answering some of the pre-submitted questions, and then we'll open it up to further questions. I think it's important also to note, as you see on the screen here, that this presentation and this webinar is not intended for any specific legal advice. It's meant for guidance for federal employees on the return to in-person work order, but it's not meant as specific guidance for your specific legal matter. If you do require specific guidance on your legal situation, please contact our firm so we could have a consultation set up. But otherwise, we'll be discussing overall guidance based on our legal opinions of the order. To get started, this is what we're going to be talking about here during this webinar. We're going to be talking about just an understanding of this new return to in-person work order, the requirements that need to be met, some of the exemptions that the new administration has allowed for federal employees. Some of the pending legal challenges that have already been made, some of the key considerations and how to protect yourself regarding this return to work in-person order. So on the next slide, so on January 20th, the president in one of his first orders mandated that all federal agencies mandate that their employees return to in-person work and terminate remote work arrangements. This was something that the administration had been talking about during the election season, and I knew federal employees were somewhat expecting this. But one of his first actions was to terminate those remote work arrangements. So this included all employees that had those remote work arrangements, even if those employees were hired into remote work capacity. Those telework agreements were terminated through this mandate. This mandate also, was requiring people that were even teleworking part-time to return in person. I think through the administration's view that in-person work was necessary for federal government employees, and full-time remote work or even part-time remote work was not in line with the administration's interests. And so I think that's some of the language I've seen as far as the reasoning for this order. And so the order specifically mandated the agencies terminate those work arrangements, those remote work arrangements, and basically figure out a way to get everybody back in the office. A couple of days later, on January 22nd, the Office of Personnel Management issued its initial memorandum trying to set guidelines and guidance for these agencies and deadlines for returning employees to the workplace. Some of the issues that OPM wanted the agencies to sort through was making sure there was enough space for the federal employees, making sure they were doing this in a cost-effective method, and especially for those employees that were living far away from any duty station, how to effectively return those employees to a close duty location. Notably in that OPM memorandum, they said the directive is being issued as a result of federal work sites being vacant. So the administration believed that return to in-person work was necessary because there was vacant office spaces that weren't being used in the DC area and other areas after the COVID pandemic. And the administration, I think, was citing different articles and whatnot in the OPM memorandum and guidance that the COVID-19 pandemic had ended, and working remotely wasn't working for the federal government, and so that was this administration's belief. And so this order, trumps, for lack of a better word, all these telework policies and remote work arrangements, and cancels them. And requires those employees to return back in the office with the agency specific deadlines, which may differ per agency, but as we'll talk about soon, OPM they set guidance that those deadlines should be about 30 days. So as I just stated, in OPM's guidance, they wanted agencies to have a deadline for full compliance for returning employees back into the office. And, the targeted date for agencies was 30 days, meaning 30 days from their guidance. Now, I think different agencies, from what I've heard, have varied on the specific date that all employers are to return back into the office. I've seen some later this month, some early March, but over the next few weeks, most agencies are requiring their employees that were teleworking or working remotely to be in office, to be working. I know some federal employees have received correspondence from their agency heads that their telework agreements, their remote work arrangements are being canceled and they must return at a specific date. Those are requirements that those employees must meet or potentially face discipline, as we'll talk about later. But the agencies were also required to revise its telework policies, to state that the eligible employees must work full-time at their respective duty stations. A key thing to note there is that these employees have to work at duty stations. That's what the mandate says. It doesn't say a specific duty station. It just says in-person work. So, for those federal employees out there that are wondering, well, where am I supposed to work, or what if this is not convenient for me? There may be a room to negotiate where you must return, especially those employees that are far away from any duty station, or it's not clear where to return. I think the agencies are currently still trying to figure that out, where to return certain employees. But if an agency has said you must return to this specific location, I think there may be room to negotiate, if possible, that you could return to a different location if more convenient to you. But because the order states you just must be in person working. Anyways, that's what the requirements are, to make sure all the remote working employees are back in person and back in person working. The OPM guidance was issued after the presidential mandate also required agencies to attempt to bring all collective bargaining agreements into compliance with the return to work executive order. And that was really issued because the prior administration and during the Biden administration, there were several collective bargaining agreements that were executed that protected federal workers and attempted to keep them in a situation where they were allowed to work remotely, and attempted to extend the time frame of those collective bargaining agreements so they couldn't be changed. Despite that, this new administration is attempting to have those agreements changed, and so they could be in compliance with the executive orders. And I know there's litigation on this issue by unions on whether or not those employees that are protected by the collective bargaining agreements and allowing them to return to stay remote are required to return in the office. But the president's mandate has required that the agencies try to bring the CBA's, collective bargaining agreements, into compliance. The agencies also are required to submit these detailed implementation plans to OPM. They were required to do so by February 7th, including the specific plan steps to be taken to implement the presidential mandate. and the timelines for compliance and identifying any cost or risk or barriers. And that is just OPM, I think, recognizing that just having a blanket statement saying everybody must return to work, needs further elaboration, because there are issues about office space mainly. Is there enough office space for each agency? And so I think, the guidance was really setting forth to make sure that there was an appropriate amount of space, that they're using the most cost-effective methods, to ensure that, these employees are returning to actual offices or, office or actual spaces where people could work. And I know that's still an issue. I know, it's a tight timeline, obviously it's been, and I know agencies are still having a difficult time, trying to figure out where employees should work when they're in the office. But that was the order, and that was what agencies were required to do by February 7th. And again, I know employees of different agencies have now been receiving notices of their return to in-person work date. That was some of the history and some of the reasoning and some of the requirements behind the return to work orders. These next couple of slides, we're going to talk about some of the exemptions and some of the legal challenges from these return to work orders, and I'll turn it over to Nora to talk more about that.
Thank you, Mike. So going on to the next slide, we're going to talk about a little bit of the exemptions of this. Obviously, requiring everybody to return into the office and in-person work to all of those duty stations is not, as Mike mentioned before, not totally feasible. And there are also some exemptions that apply here. For one, people with a qualifying disability. So if you have a reasonable accommodation, or if you have situational telework or something like that, or if you're out on short-term disability, something like that, that is one of those exemptions that qualifies you. Another one is a medical condition. Like I said, anything that will qualify you for a reasonable accommodation, or if you're out on, again, if you have some sort of situational telework or a temporary telework agreement or something of that nature, that would be an exemption that would apply as well to this presidential mandate. Another reason that was brought up in OPM's guidance, which is a little bit more ambiguous, is something that they have defined as an other compelling reason. Now, OPM has left that very vague. They are leaving that up to specific agencies to determine what could be considered a compelling reason. As Mike previously mentioned, it could be something as simple as certain employees are not currently located near any sort of duty station, or they are overseas or something of that nature, or they have situational telework for another reason that's unrelated to any sort of medical condition or qualifying disability. In that case, OPM is leaving it up to the agency's discretion on whether that would qualify them to be exempt from the return to work or return to office presidential mandate. And that is something that is honestly very situational. It's going to have to depend on your specific agency and, again, what they are deeming as a compelling reason for not, for leaving some of those employees as exempt from these requirements, which we are going to continue to kind of monitor as more guidance comes out from those specific agencies. Another group of people that are exempt from this are military spouses. And this is actually very newly developed. There was a military spouses and military service members union that filed a lawsuit against the presidential mandate. And it was OPM quickly acted on that and noted that military spouses who were hired and are working remotely within the federal government under the Military Spouse Employment Act, or honestly are just working in that capacity, or are considered a domestic employee teleworking overseas, a DITO, that they are exempt from this, which is really great, honestly, because they recognize that military spouses, who are often overseas or in a different duty location, are really there to kind of maintain the integrity and the unity of their family units. And so they are going to be exempt from this. They will not have to return to the office or return to any of those duty stations as long as they are considered an active military spouse. So as I mentioned, there are some legal challenges that have been going on. There's several lawsuits that have been filed against this presidential mandate, particularly from other unions, right? As Mike mentioned, one of the guidances suggested or directed agencies to work with the collective bargaining agreements that they have in place to kind of revise those terms of that collective bargaining agreement to ensure that those employees do return to the office and return to their duty stations. So there's a lot of legal challenges that are currently that have been filed, are getting ready to be filed, or are currently being processed. Right now, we don't have any answers on those. A lot of those are still very freshly litigated. We don't know whether they're going to continue and gain more traction, if they're going to be dismissed, if they're going to be withdrawn. There's a lot that's still a little bit unknown. The reason we want to bring this to your attention is because we don't necessarily want anyone to kind of wait to see what the outcome of those challenges are, because it could take several months up to years for that to kind of even gain traction or to be decided. So what's best for you is to really kind of to consider your specific unique circumstances with your employment, what your goals are with your federal employment, and kind of what you're looking to achieve, right? So we don't really necessarily advise anyone to wait to see what the outcome of those legal challenges will be. As I said, it could take a very, very long time for there to be any sort of definitive statement about that. But we will, as always, continue to kind of keep monitoring that situation. And we will hopefully be doing additional webinars in the future to kind of go over those. But of course, as Mike said before, if you want to speak about your specific situation and your subjective goals and things like that, you can definitely reach out to us and schedule a consultation, and we can talk about that a little bit more in depth. So with that, there are some considerations for this, right? Of course, if you have, with this directive, if your agency has issued guidance saying that you do have to return to work, there are some things that you need to consider, right? First of all, the biggest question that we've been receiving regarding this presidential mandate is this legal, right? Or is the federal government allowed to require all employees to return to their duty stations and return in person? And the short answer is yes, right? The federal government is within its authority to require that all full-time employees present to their in-person duty stations. That is part of your condition being an employee with the federal government. So they are allowed to do this, right? Of course, they do have to comply with certain, legal like statutes and things like that, and pieces of legislation that protect employees, such as the Americans with Disabilities Act, the Civil Rights Act of 1964. Of course, it has to be within those confines. Like I said, still permitting people to seek reasonable accommodations, right? That kind of thing. But they are allowed and permitted to require employees to return to the office in person to their duty stations. Second, a lot of questions are what happens if, you don't want to comply with this return to office mandate, right? What does that do? What does that mean for you? OPM has advised agencies in their most recent guidance to respond to any non-compliance with their employees within their discretion. OPM, as I said, OPM is a little bit ambiguous about that. They're leaving that entirely up to agencies on how they want to handle non-compliance, the same way that they're allowing them to handle anything that's considered a compelling reason, right, to be exempt from the mandate. But it is very likely that agencies, if you decide to not comply with this mandate, that they will charge you with absent without leave or AWOL, or any other disciplinary action, right? Up to and including removal. So there are some concerns whether, some employees who don't want to follow the return to office mandate, if they don't want to either, if they don't qualify for a reasonable accommodation or have a qualifying disability or a medical condition, or don't have an otherwise compelling reason if they don't want to return to the office. If you don't follow that directive from your agency, you could face disciplinary action. So that is something to consider. And then another question we received, which is, what if I'm currently located more than 50 miles from my duty station, which is a very common question. Obviously, during the COVID-19 pandemic, a lot of employees were teleworking and remotely working, and were able to either relocate to another state or another city, that while they're still able to kind of work, and report for duty. If you do work more than 50 miles from a duty station, OPM has been advising all employees that they should still report to the closest facility that is nearby, or otherwise start making arrangements to relocate to a new duty station. Now, OPM does recognize that this is not going to be a quick procedure or process. They have noted in their guidance, specifically to agencies, that this will take time, particularly for employees that are located very far away from duty stations, again, 50 miles or more. So given kind of what we've seen so far, they are kind of giving some leniency in that, and understanding that, again, that this is going to take some time to fully implement and to get full compliance. However, it is not advised to kind of take time with that, right? You want to make sure that you're remaining in compliance with whatever your agency is directing you to do. Obviously have that open correspondence and communication with them about what those next steps will look like. As Mike said, some agencies have already issued guidance specifically to their employees about it. Some agencies haven't. So this will be a little bit more situational, depending on where you are employed and what they're noting as a requirement for you, and in your position specifically. But OPM is advising them that they should tell their employees to locate to the closest facility that is available to them, or otherwise start making arrangements to relocate. So one of the probably the next questions you're thinking of is what you can do specifically, right? Of course, there is a lot of air of ambiguity and vagueness, and as a result of this presidential mandate, because there is a lot that's still being decided, particularly with a lot of those legal challenges, some of the unions that are kind of giving some pushback on amending those collective bargaining agreements that they may have had in place for years, if not decades, right? So of course the question, and I'm sure why you all are here, is what can you do and what are your rights, right? So if you are a federal employee, a full-time federal employee, and you do not want to return to the office, one of the first steps that you need to take is to determine whether you qualify for any of those exemptions that we noted before, right? So whether you have a qualifying disability or a medical condition, or if there's any other compelling reason that you can provide the agency as to why you should qualify for an exemption. Again, as I said, that is left up to the agencies to determine what they will consider and define as a compelling reason. If your agency has already issued any guidance about that, refer to that specific guidance, right? If your agency has not yet issued that guidance, we advise for you to first wait and see when that is issued, so that you can kind of figure out what those next steps would look like for you. Okay. If you do have a qualifying disability or a medical condition, say you already have a reasonable accommodation in place, either to telework, or you have a hybrid schedule or something like that, that is something that you can discuss with your RA coordinator. It's particularly your medical providers, to see if you potentially maybe qualify for full-time telework. Of course, again, if that's something that you really want to talk about more in depth, definitely reach out and we can schedule a consultation, so we can kind of go over your specific situation and whatever is going to impact either your renewed RA request or a new one. If you are a federal employee and you still don't want to return to work, but you don't qualify for any of those other exemptions, right? And again, you're still waiting on what is considered a compelling reason, right? There's that's a little bit of a difficult situation. We're still going to, it depends on what your agency is going to say, again, about the compelling reason. We're going to have to wait and see kind of what, some of the legal ramifications are, or what the results are from any of those legal challenges. But as of right now, what we know is that the only way you can be exempted from the presidential mandate is whether you have a medical condition, a qualifying disability, or you may be qualified for the compelling reason that your specific agency will define for you, and you can discuss that with that agency. Right now, there's no other exemptions that we're aware of, none that have been communicated by OPM. Of course, like I said, we will continue to monitor the situation and provide updates as they become available, but that is what we know as of right now. Okay, so now we will move on to some of the questions that we've received. We received a few of our questions that were submitted with the registrations. So the first question that we received was, how does this memorandum impact employees with a reasonable accommodation in place? As I mentioned before, if you have a reasonable accommodation to telework, either part-time or fully telework, this should not be impacted. The agencies might kind of follow up with individuals who do have those reasonable accommodations in place, either to kind of confirm that, or maybe ask for additional medical documentation like a renewal. But of course, you'll have to, we'll address that as you get to it, right? But if you have a reasonable accommodation in place to telework and you have that supporting medical documentation, you are considered exempt from the return to office mandate. So you should be okay with that. Okay. Mike, do you want to take the second question?
Sure. So when we're also getting questions, I know people are submitting, but as far as the accommodations, just to piggyback on that, these are accommodations to telework. So some employees already have accommodations in place, which, according to the mandate, should continue. And if they don't, I think that could be a violation of the ADA or the Rehabilitation Act. But these accommodations are accommodations for telework or remote work due to a qualifying disability or medical condition that are usually allowed, for under the Rehabilitation Act. And if you don't have an accommodation in place, there is and still exists a reasonable accommodation office, reasonable accommodation process for employees to use to obtain an accommodation. Some of the questions we were just getting as well was about the Telework Enhancement Act of 2010 or prior Telework Enhancement Acts. I guess to be clear, this presidential mandate is trumping, so to speak, these prior orders. This is the mandate across the federal government for employees to return in person to the office, except for those exemptions that Nora was describing. That is not in place. Those prior telework acts, were acts to allow employees to telework, but this administration's standpoint is that they control the executive branch. They control how employees and where employees should work. I know that will be subject to further litigation and discussion amongst Congress and amongst, in the courts, but that is where we stand. As far as the collective bargaining agreements are concerned, and what happens if you're covered by a collective bargaining agreement and you're being forced to return to work, I think what you should do is talk to your union, and there's probably a mechanism to file a grievance. And I'm sure, and I think unions have already, contemplated or have already filed grievances or lawsuits on behalf of employees. But that is something you should contact your union official about and look to ways to file a grievance of whether or not you could remain in your remote work status based on your collective bargaining agreement. Well, another question we've received is if your closest facility doesn't have space for you to report to, can you be terminated legally? So that's a good question. And I guess it's kind of a two-part question. And I'll take the second part first. If your agency has ordered you to return to work and you are not agreeing to return to an in-person office, then the agency likely will take steps to remove you, to consider you as AWOL, to consider you as not complying with agency instructions. I guess the first part there, if the agency doesn't have space for you, I think that goes back to what I was saying earlier as far as, some sort of negotiation of where you must return in person. No, I don't think it's reasonable for the agency to say, well, we don't have space, so you can't return to work, therefore you're fired. No, I don't think agencies are going to do that. I think if the agency doesn't have space for you, then they'll probably find space for you. And I think that's your opportunity to perhaps negotiate with your agency to identify an agency facility where you could work. If the question pertains to the type of space, unfortunately, at this point, I think that's going to be up to the agency. If you were looking for an in-office setting and they're putting you in a cubicle, I think that's going to be the agency discretion under this presidential mandate. And I think that's something you would have to accept to avoid any sort of discipline. But as far as if there's just no space, I think an agency, I think it would be unreasonable for an agency to try to take disciplinary action against you if there wasn't actual space for you. Let's see, Nora, feel free to, jump in if you want to answer any other questions.
Yeah, there's we've gotten a couple of questions about federal contractors who are working for private companies, but working on government contracts. Obviously, when you're a federal contractor, it gets confusing because you're working on federal, contracts and grants and things like that. But if you are a federal contractor, you are not a federal employee. You are a contractor that works for a private company for which the federal government has contracted out some of those duties and some of those responsibilities out to a private company to assist with. But you are not a federal employee, so this does not pertain to you. You are still privately employed, and you are still bound by the laws regarding the private employment within the jurisdiction within New York. So I know that it's kind of confusing when you're a federal contractor, but you are considered a private employee and not a federal employee. So this does not pertain to you. And I think I just kind of wanted to piggyback on what Mike said, because OPM was pretty specific regarding, this, acknowledging the difficulties and kind of implementing the mandate for people to return to duty stations, because a lot of employees have been hired over the last few years, while, during the COVID pandemic, as well as afterwards when telework was still a big option, when people were hired specifically for remote work, right, or telework. So naturally, a lot of those office spaces, weren't accommodating for, the agencies of that size. So OPM has acknowledged that, that is going to be difficult, right? To kind of coordinate, and they've left a lot of that discretion up to those specific agencies to kind of troubleshoot that situation, whether they need to find alternate duty stations, or whether they will kind of figure something else out. I think they are also knowledgeable, or at least recognizing the fact that a lot of, this isn't going to apply for all employees. There are those exemptions in place, right? For people who do have reasonable accommodations or other compelling reasons, right? So, but I want to clarify that OPM has acknowledged that. And that they recognize that it's going to take some time, particularly for those individuals who did go out, either out of state or out of the city, right? Particularly during the pandemic, and that it is going to take time for them to kind of, figure out those arrangements and those accommodations to return to their original duty stations. So that is something that I just wanted to clarify. One question we just got was, what kind of documents should I start gathering to submit for a reasonable accommodation? Definitely medical records, right? That is something that is going to have to be reviewed. Of course, reasonable accommodations, requesting one doesn't guarantee that you're going to get that accommodation that you were requesting. It just has to be reasonable to address your specific parameters and your limitations according to your condition, right? So, getting those documents from your medical providers that really outlines, your specific diagnosis, your limitations, right? How your limitations impact your ability to complete your duties and responsibilities of your role. Because those are all questions that your reasonable accommodation coordinator or specialist is going to have for you, right? They need to understand exactly what what you need assistance with, so that you can complete your role as efficiently as possible. Now, if you are requesting a full-time telework, that is something that is going to have to be very, narrowly discussed and evaluated, right? If it has to be very tailored. Again, if you're requesting that, they don't have to grant that specific one, but they do have to present a reasonable alternative, right? Under the statutes, agencies have to kind of engage in that what's called an interactive process, right? Where, if full-time telework is not reasonable for you, then, they have to kind of discuss what other alternatives could work, right? So it is kind of a little bit of a back and forth. But if you're looking to kind of get that process started, obtaining those documents is incredibly helpful, because that is something that they're absolutely going to ask for, either upfront when you first submit your request, or they'll ask for any supplemental documents as they kind of evaluate your request. So that's definitely something to kind of start anticipating and getting prepared for.
Yeah, and a follow-up question from that is just how long it will take to get an accommodation. Well, the law states it has to, the agencies must respond within a reasonable amount of time. It doesn't state a specific deadline. Some agencies have in their policies the goal it wants to respond and determine an accommodation. I think it's usually around 30 days, but that's again not necessarily set in stone. I would imagine through this process, agencies will try to address the accommodation request as soon as possible. But as Nora said, there's an interactive process, and that involves going over your reasoning for requesting the accommodation, the medical documentation that shows that you do need to work from home, and your meetings with your reasonable accommodation coordinators and relevant management officials to determine whether you can be accommodated. In my experience, the process could take several weeks to perhaps, several months, just depending on the responsiveness of, possibly yourself or your medical providers, and or the agency officials. I think it's important to keep in mind that failure to accommodate claims can be claims made to the EEOC, or those could be EEO complaints, which our firm does represent individuals in. Specifically, if the agency fails to accommodate you, that could be a violation of law, and that's a claim you can make to the EEOC to claim that the agency failed to accommodate you. Another follow-up question we just had is, could the agency refuse to accept accommodation? Yes, they can. If the agency views the accommodation request as an undue burden upon the agency or an undue hardship, then the agency could view it as, as an unreasonable accommodation request. I guess in this scenario, it's really going to be dependent on the medical documentation or the supporting documentation supporting the accommodation request to show that you are a qualified individual with a disability that cannot work in person. Because the agency standpoint, likely for an undue hardship, is going to be, well, this is what the president has ordered, and it's going to use some of those reasons that I talked about earlier as the reasons why people need to be in person, and some of the OPM guidance they set forth as their reasoning. What's the worst case scenario? Well, I guess, the worst case scenario for somebody is that they don't have a qualified medical condition or an accommodation that would allow them to work remotely, and that agency starts taking adverse actions against them to possibly include removal. I would imagine that's a worst case scenario for an employee.
Another question that we got was, if I have to relocate, can I get any relocation expenses reimbursed? That's a great question. Unfortunately, no. They can still require you to come in. At least that's the guidance that we have right now. Now, Mike made a really great point earlier about, whether they're requiring you to come in person, but they don't have any room for you or something like that. Again, this kind of air of other compelling reason, right? That is left up to the agency's discretion, depending on your situation, right? If that is something that is, if it's going to cost a certain amount of money to relocate, say you're very, very far away from the duty station that they're requiring you to return to, that could be a conversation that you have with the agency, right? Whether that qualifies as a compelling reason, or whether you can maybe try to negotiate your situation, so that maybe you go to a different duty station that is closer by rather than the one that they're telling you to report to, right? That is going to be very situational. Of course, once you have your guidance from your agency, there'll be a little bit more of information on the best way to handle that. But there's nothing in any of the guidances that we've read, either from OPM or from the individual agencies that have issued their own guidance, that says that, they will offer that, right? Because they are within their authority and their discretion to require employees to return in work or in office work. So, there's nothing that they're currently offering regarding relocation. But again, once if, whoever asked that question, whoever, your agency is, and regarding their guidance, whatever they consider to be a compelling reason, right? I think it's at least worth to inquire, right? About, whether your situation applies. But as of right now, there's nothing in the guidances that say that, if you are outside of that, 50 plus miles outside of that duty station, or you are very, a state or two away, that they will offer relocation for requiring you to return in person.
Yeah, I think that is a great question, because I think agencies really probably don't know the answer to that yet, especially for one of these follow-up questions we just received for those employees that were hired as remote employees. I know there was employees that were hired to be remote, and they're probably working, a few states over from an office location. And I don't think there has been guidance on whether or not, having to relocate to a location, move states, whether the agency would pay for those relocation expenses. Where relocation expenses are normally allowed is when the agency is relocating you to a different agency, or perhaps you're even taking a new position, and the agency is agreeing to pay, relocation costs. But I think, what OPM required from these agencies was to submit their detailed plans on, the most cost-effective methods to require people to return back to the office. So I'd imagine agencies should have at least contemplated, whether or not they must, expend costs for employees to return. But I don't think there has been, guidance from OPM on that. I probably expect that to be, guidance that will be issued soon. But like Nora said, you should ask. I think you should bring that up, especially if you are remote, if you were hired into a remote position. And I guess to overall answer that question on people that were hired remote, this mandate is requiring that you work in person. So I would imagine if you haven't already, you'll be receiving notification from your employer to say you must return to this specific duty location. I hope that notification includes, any relocation costs, but if it doesn't, I think you should request it. Because in my opinion, yes, it could be unreasonable for you to be hired into a location, in one state as a remote employee, and then have to report to work in another state because of this mandate without any benefit to you, and you're willing to do so. So I think I urge those people to request that compensation. And is the VA writing reasonable accommodation letters? So to request an accommodation, that is you. You are requesting the accommodation for yourself, and you are gathering the accommodation documentation to support your accommodation request. If it's a medical accommodation, you're gathering, the documents to show that you have a disability, and that disability, does require an accommodation of telework or remote work. It's not necessarily a specific agency. If your records exist with the VA, then you can, seek to obtain those documents from the VA. But the VA isn't necessarily writing those letters on your behalf. And so, this presentation, we're getting some other questions about RIFs and probationary terminations and whatnot. This is specifically about return to in-person work. We have done webinars and videos at our firm on the deferred resignation programs, on probationary terminations, and related videos that I urge you to go on our website and go on our YouTube channel and look at. But this video is specifically meant to address the return to in-person work requirements and to provide guidance on that.
Mike, we've gotten some specific questions about, people noting like their specific medical, disabilities and things like that. If you have a qualifying medical disability, right, or medical condition, right, you can request a reasonable accommodation. And we urge, people to do that, right? At least begin that process. While we can't necessarily advise on anyone's specific medical condition, right, that they've noted in the chat or anything, you can absolutely kind of begin that process within your agency and request a reasonable accommodation. All you have, like I said before, all you have to do is kind of start gathering those medical documents that you have, even the work with your provider, to either get those medical documents or have them kind of elaborate a little bit more on your limitations, right? And kind of what you need in order to complete your duties and responsibilities in your role. But if you have that qualifying disability or that medical condition and you are seeking, reasonable accommodation, whether it's for telework, right? Go through that process and kind of get that started. You can also ask your reasonable accommodation coordinator or your specialist directly, right? You can say, does this apply for me, right? Am I within, do I qualify for a reasonable accommodation, right? If you want to get a little bit more specific information on your position, again, we can't necessarily go through, each question and kind of, remark on that or provide any advice there, but definitely start working through that process. You can ask your reasonable accommodation coordinator directly, or you can book a consult with us and we can kind of go over your details more, more in depth to kind of see, whether you qualify and what your next steps could be. I think there's also some specific questions, regarding your collective bargaining agreement. If you're a union member, there's certain, people have noted that there's like certain phrases or stipulations within their collective bargaining agreement, related to like legitimate business reasons or anything that would kind of, spur terminating any remote work agreements, right? We can't necessarily, comment on any specific collective bargaining agreement, of course. But as we mentioned earlier in the presentation, OPM has directed agencies to revise those collective bargaining agreements, right? To make sure that, the return to office mandate is implemented, right? And as previously mentioned, some of those unions have in turn, lodged legal actions against the mandate, right? Noting that it was either a breach of contract or something like of that nature, right? So, if your collective bargaining agreement has something like that, definitely speak to your union representative, right? Reach out to your union, discuss kind of what that situation looks like, where they are, if they have initiated any action, kind of where they are in that, and ask for this specific advice. Because again, right now we're in a little bit of a limbo regarding those specifics, because OPM did direct agencies to amend those collective bargaining agreements. But of course, those are very specific, right? No two collective bargaining agreements are the same, particularly as they, vary based off union, based off agency, right? Those terms that they agreed to, are very, very different. So, if your collective bargaining agreement has some sort of term like that, right? And you have questions about it, definitely reach out to your union representative to discuss that more in depth and kind of get a little bit more information on, what actions they are taking, if any, to protect their union members, or, anything that they can assist you with.
I just wanted to address a couple other questions we were getting. I mean, one was just really the legality of all this. And, we talked about the Telework Act, the prior Telework Acts that have been implemented. I think there are and will be challenges, whether this is, illegal or not. And I know unions will make challenges. And as I said earlier, I think it will be determined whether these orders, not only this one, but other orders, are legal. I think another good question that we got as well, even prior to this webinar, is how does it impact situational telework? And I take that to mean, well, what if, I don't have a telework agreement, but I need to telework one day because, of some personal issue, I can still work. I don't think there's been any specific guidance on that, but I would imagine that, and based on my understanding of the presidential mandate, that this really is canceling those telework agreements for full-time remote work and for individuals that have telework set up where they're teleworking 1 or 2 days per week. I think if individuals need to telework for any specific reason, on a day or something, I think that's going to be in the agency's discretion. And I would imagine, in my opinion, that there's going to be discretion allowed in certain situations, and those situations are going to continue, and they can't really be stopped where individuals need to telework. But I think that's going to be outside of a telework agreement. That's going to be a manager's discretion to say, okay, yes, you can telework on this specific day. I think if you have an agreement that says you're allowed to work or telework on an as needed ad hoc basis, I would definitely have a conversation about that with your supervisors or managers, whoever that may be, to determine, how this impacts you. If it's based on an accommodation, I would work to ensure your accommodation is still in place. If it's not based on accommodation, I think technically you do have to view that as that being canceled. But if there's, reasons you need to telework, then I think you could contact your supervisors when needed to telework, and that will be in their discretion on whether to grant. But overall, I don't believe there's any specific guidance saying that there can't be ad hoc telework. I think it's really meant to be on the remote work arrangements. Okay, well, again, thank you for joining us. Nora and I both work in our Federal Labor and Employment Practices Group, and we defend the rights of federal employees. Our contact information is there on the screen. So, if you have further specific questions about your legal matter, about your specific situation, please contact us, and we'll be happy to conduct a consultation about your matter. But again, thank you for joining us, and I hope you've received, good information from this webinar.
Yep. Thank you, everyone. And a recording of this webinar will be sent out. So if you didn't get to join on time or you joined late, it will be sent out. So just be on the lookout in your email. But thank you so much for your time today, and we appreciate it.